Thank you.
Thank you, Senator Moran. Senator Reed.
Welcome, General. Last summer, the Senate Banking Committee passed the Safer Banking Act. It's a bipartisan legislation designed to help state-approved marijuana businesses access banking services. Section 10 of the original legislation would have compromised law enforcement and national security by requiring banks to notify customers when the government requested termination of an account. In essence, the original language meant that serious criminals could be tipped off that they are under investigation. That includes fentanyl distributors, gun runners, mob bosses, etc. Fortunately, through a bipartisan committee process, we worked to address major flaws in Section 10 and curb its negative effects. Do you agree that such a policy would handcuff law enforcement and the intelligence community if the bank had to disclose that their account has been terminated by law enforcement?
I have to say I'm not familiar with the provisions of, I know what the act is and the proposal. I'm not familiar with the requirements in general. As a theoretical matter, without commenting on that, obviously, if we are investigating someone and that person is advised of our investigation, that makes our investigation all the more difficult and may compromise it. But I can't answer specifically with respect to the statute.
Let me prepare a letter, send it to your office so that you and your staff can review it and then respond. I know when you come up here, it's sort of a range of issues from all the way across the board, so I completely understand that. A quick other question, and again, this might not, I think you would be familiar with this. The reauthorization of FISA, there was a great debate in the House about a warrant requirement. Would you support a warrant requirement for U.S. persons in 702?
So 702 is absolutely essential to our ability to protect the country from everything from nation states to foreign terrorist-inspired attacks in the United States. I don't support a warrant requirement. We are talking about information that has already been lawfully collected pursuant to a court order because the target is a foreign individual operating abroad where foreign intelligence information is likely. And courts have never required us to search lawfully collected holdings with a warrant. So I don't think it's constitutionally required. I am concerned about errors in the query system that occurred. And when I first came in, these were reported to me, and I directed the Deputy Attorney General and the FBI Director to put in quite a number of fixes in to prevent that problem, and the consequence has been a really large decrease in the number of queries that are made in excess of 90%, and a compliance rate in the area of 98%. The problem with a warrant is that a warrant requires probable cause of something, and we don't have probable cause at the stage of the query. Query is intended to find out what's in our holdings so we can determine whether we have a probable cause. If you impose a warrant requirement with a probable cause requirement, it effectively makes queries impossible to go forward. So it would just eliminate our ability to use 702 to find out what information we have with respect to foreign terrorism, with respect to cyber attacks, with respect to foreign intelligence collection by our adversaries.
Mr. Secretary, Attorney General, as you understand, there is a immediate requirement to renew FISA because it lapses.
Yes.
Are you comfortable with the House version of the legislation?
Not knowing exactly what the House version is, I'm comfortable with the provisions that provide for the fixes that we have administratively put into place, and that do not require, though, a warrant requirement.
Thank you very much.